Salut! English courts apply the concept of consideration to determine whether there is a legally enforceable offer and acceptance towards a contract between the parties. A consideration applies when both parties mutually exchange something amongst each other, which in effect also goes to the concept of binding relations that is created amongst themselves before they actually enter into the contract. The classic definition for consideration was given in the case of Curry versus Misa, where lush justice said, "A valuable consideration in the sense of the law may consist either in some right, interest, profit, or benefit accruing to the one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other." It is important to note that there is no need to transfer or exchange something tangible or physical between the parties. Even a mere promise would be sufficient to amount to a consideration. Let's take a look at executory consideration and executed consideration. Executory consideration occurs when both the contracting parties make promises to each other to do something at some point in the future. So for instance, when it comes to online buying and selling, the seller will promise to deliver you the goods at some point in the future, and you make a promise that once the goods are delivered, you will make the required payments. So up until the goods are delivered, you and the seller has done nothing with respect to performance of the contract. However, the contract still has contractual validity because of the executory consideration involved. In the case of executed consideration, where at the time of performance or formation of the contract, the consideration has always been provided, given, performed, that will amount to executed consideration. So if, for instance, you promise to pay a reward to anyone who finds your lost dog, so for someone to actually go out there, look for your dog, find it, and then bring it to you is performance on their part, and that amounts to consideration on that part, and that is executed consideration. Let's look at a few rules for consideration. So past consideration is considered ineffective. So for instance, if I mow your lawn without you having even asked me, so there was no consideration on your part, you were not required to make a payment because you had not asked me to mow your lawn. You had not asked me or told me that you will be paying me this amount for mowing your lawn. So that is why any performance that I give in that regard would not amount to consideration, and hence no contract would be formed. Secondly, consideration need not be adequate, but it must be sufficient. What that means is that even if I were to pay you a single penny as consideration for you to be bound by your contract to sell me your Rolls Royce, you are in effect bound. And this goes to the rule that consideration need not be adequate, but it must be sufficient. It should have some value in the eyes of the law, and the court will not necessarily look into the bargain if both parties have freely agreed. Thirdly, consideration has to move from the promisee, but not necessarily to the promisor. So guys, this was about consideration, executed and executory consideration, as well as some of the rules that apply to consideration when courts actually determine whether the offer and acceptance between the parties can be enforced. In my next video, we will look at part payment of debt and whether that can be enforced. Thank you.